Alrighty, well thank you everybody for coming this morning. It's a pretty important topic and one that we've seen lots of changes to in the last, 6 months or so, maybe a bit more.
Yep.
So it's a good opportunity to find out what all of those things actually mean for us. So just a little bit about Jonathan. Now he asked me to summarise this, so I think the easiest way for me to do that is to read every third word. Jonathan, South, and employment with... Maybe I'll read the whole thing.
No.
Yeah. So Jonathan Mamaril is a director of South Girl Lawyers and heads the employment law team. With a distinct trade union background, Jonathan possesses unique insight into how employee advocates and lawyers work, allowing him to provide strategic and practical advice that keeps employers and human resources teams one step ahead. Providing practical and timely advice on the latest legislation changes and legal issues facing employers, Jonathan advises decision makers on all areas of employment law, including restructures, redundancies, general protections, unfair dismissal, sexual harassment, psychological risks and hazards, workplace bullying, underpayment of wages, termination of employment, and performance management. Phew, that's a fair list. Due to his practical expertise, Jonathan is regularly asked to comment on employment law matters with the Brisbane Times, Sydney Morning Herald, ABC Radio, HR Daily, and HRM Online, and is a regular speaker with the Executive Connection Vistage Worldwide, Best Practice Network, Local Government Managers Association, and Australian Payroll Association. And you've left something off here. This is your second time speaking.
I know.
According to Chamber of Commerce.
I just realised that.
Most important part of the bio is missing.
Apologies.
Geez, I have to fix that up for next time. Anyway, without further ado, here's Jonathan.
Thank you. Thanks so much, Jason. That was a great introduction, even though it was exactly read from my bio, but that's lovely anyway. So thanks for having me, guys. Today is going to be a bit of an interactive session. So if you're hoping to sit there, get on your mobile phone, get on your laptop, do a little bit of work, I'm probably going to zero in on you and ask questions. But it's okay. It's all going to be very... it's really in a more safe space, yeah? So we're all here as either business owners or people in decision-making positions. And that's, from that perspective, I do encourage active participation in the discussions, okay? Of course, I'm aware of time and things like that, and I'll try to control that, but I do want active participation as much as possible. All of you are going to have a question as I go through this, many questions even. I have a golden rule, just wait one slide. Wait one slide. If I haven't answered your question, put your hand up. Does that sound okay? Yeah? Great. Now, this can be a very politically charged topic or topics. Do we agree? Yeah? I'm not a politician, all right? I'm a lawyer, okay? So I can't give political views. However, I do want everyone to respect everyone's views and opinions. Is that okay? Yeah, brilliant. All right, and of course, you know the normal stuff. This is not legal advice. It's guidance only. Sound good? All right. So we have so many industrial relations law changes, so many. I've just picked out a few, right, that we're not covering today. But for example, you've got psychosocial risks and hazards, changes around work from home and flexibility, multi-employer enterprise bargaining, sexual harassment. There's been changes around paid parental leave, and there's even paid transparency laws as well, yeah? There's possibly going to be a few more around restraint of trade, etc. So many laws, okay? So what we're going to tackle is three of them. Contracts and subcontractors, there's a bit of change around that. We're going to also dive into the right to disconnect. And then for those who love their numbers, we're going to get into wage theft and underpayment of wages, okay? There'll be a QR code that will pop up every now and again as well. If you scan that QR code, you'll be able to get a copy of the slide deck, but also get invites to future webinars in the future. Sound okay? All right. So before we really delve into it, do you guys like playing games? You do? It wasn't really going to matter what you guys said because I want to continue, right? So let's go. All right. Who remembers Who Wants to Be a Millionaire? Yeah? So for those who don't know, basically I'm going to ask a question, okay? Now, that question has 4 potential answers, all right? But to make things interesting, if you get the correct answer, there will be a chocolate at the end of the rainbow. A chocolate. And a pretty good chocolate from Cadbury. All right, so here it is. What you're going to do is, I'm going to ask this question, and you're going to introduce yourself to the person next to you, and you're going to discuss it, and you come to consensus A, B, C, or D. Here it is. According to a prominent industry association, which IR law changes cause the most hours spent providing advice to employers? That is, what has worried employers the most? Is it A, employee issues, B, wages and entitlements, C, workplace health and safety, or D, workplace flexibility? All right, introduce yourself to the person next to you, discuss, come to a consensus. If you're in a group of 3, that's okay too. Groups of 3 are fine too. All right, are we ready? Have we come to a consensus as a pair or a group of 3? Yes. Yes? 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 Everyone yes? Whoa, 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 whoa. Got to come to consensus. Come on. Teamwork. Teamwork. Come on, pick it. All right, ready? All right, now, put your hands up if you say D, workplace flexibility. Good guess. Good guess. Unfortunately, you are incorrect, so no chocolates for you. Who said C, workplace health and safety? It is also a quality guess, but also you are incorrect. Okay, so it is down to employee issues or wages entitlements. So who said B? And who said A? Who said A? All right. All right. No one gets a chocolate. Chocolates are only for winners. All right, so this is actually in the order of the pain that employers are facing in terms of, so this industry association was taking care of retail and timber, okay, the two industry associations. So workplace flexibility was number 4 on the list. Workplace health and safety was definitely a big one. Wages and entitlements, especially around the wage theft issue that we're going to talk about very shortly. But employee issues were still the thing, yeah, dealing with employee issues. Whether
just like employment law, isn't that just a trick question? Number 1 should be all of the above. Employee issues.
No. Okay. Sorry? Yes. Wait one slide. All right. So employee issues was one of the problem. The main problem. And so one of the things why I bring this up today is because a lot of these issues were the catalyst for some of these changes. Okay. A lot of these issues were the catalyst for these changes. So when we it's not about a commentary. This is not about a commentary on whether these laws are good, bad, or indifferent. It's not a commentary on that. This discussion is about what these laws are and practically how it works for your business. Does that make sense? Okay? All right. All right, let's get into right to disconnect. Did you want to ask your question? Okay, all right. So employee issues mainly was dealt with performance management issues, issues around termination of employment. They were the main problems. Yeah. A bit of recruitment and a bit of retention as well. Okay? So let's get into right to disconnect. That's the first one. Has everyone heard about right to disconnect? Yeah? Okay. So this is what it is. Employees will have the unequivocal right to not monitor, read, or respond to any work-related communication from their employer after hours. This includes contact attempts from third parties related to work, like clients or customers. Now, small business, I've said next year, but small business, that change will come in 26th of August, 2025. So who has a small business here or less than 15 staff? Yep. So for those who have less than 15 staff, you need to get ready for that change. For those who have more than 15 staff, this change is already in place for you. Okay? So just have a think about that. It's unequivocal right to not monitor, read, or respond to any work-related communication. All right, that includes contact from third parties. What's everyone's thoughts about that? Yes, okay. Yeah, okay, so impractical, right?
That's it.
Well, that is the actual unequivocal right. Okay, so what's your name, sorry? Tanya's brought up the issue of contracts, which we'll talk about in a moment. But that is the unequivocal right. I can disconnect. Well, if I work if my hours, contracted hours are from 9 to 5, I'm just saying 9 to 5. 9 to 5, and I get contacted at 5:10, 5:15, 5:20, I have unequivocal right to disconnect from that communication. Do people see some problems with that? What would be a situation where that might be problematic? Yep, so just to contact them as a casual employee and say, hey, casual employee, you're going to be text message even, working, 2 o'clock tomorrow. Yeah? Yep. So for work purposes in terms of when they're going to work or their roster, definitely there'll be situations where you need to contact them. What other situations? Yep. Okay, so just checking in to see if they're okay. Tanya, you mentioned it's contracted, that they're salaried employees and there's a expectation that they work long hours or at least work to get the job done, right? Yeah, would that be right to say? Yeah. What else? What other situation? That's the contracted hours is till 7. That would be the unequivocal right after that. Okay. Yep. So we can see that there's problems, right? So Dan, yep. So shades of grey. Okay. Low, but difference between low and high priority. So maybe an emergency or something urgent. Yeah. Would be that right to say? If there's something urgent, we need to get onto that. Okay. So there are a few issues with this right to disconnect, and so there is a provision that says the refusal to connect must be reasonable. Now, the next question you have in your minds is, what is reasonable? Okay?
How do you know it's reasonable until you've taken the call?
Oh, okay. Let's wait for the next slide. Are you answering questions here? Okay, here we go. So, what is reasonable? That's a reasonable question to ask, right? So, here are the factors that come out of the legislation. All right? And we've discussed some of them. So, an obvious one, the urgency. Urgency of it all, yeah? It's urgent. Project manager, there's about to be a handover in 1 week, 2 weeks' time. The expectations are you're going to be onto everything to make sure, at any time of the day, to make sure that project finishes on time. Because the commercial ramifications are massive. Make sense? That would make sense, right? Yeah? The disruption caused. That would also make sense. Correct? Yeah? Major disruption. I'm thinking, is there a particular industry that you think that would be required or should be contacted outside of business hours or regular business hours? There's a few of you guys in the room. IT. I think IT would be one, for example, for sure. Absolutely. And here we go, compensation for availability outside of regular hours. And that's what we talk about, the contracted side of things. So we have a salaried employee, you're paid well above any award wage. It might not even be award for you, for that employee, but you're paid to be available outside those hours. Yeah? Does that make sense? Yeah, that's reasonable. Yeah. The nature of the role. Would there be a situation where a nature of someone's role might mean they need to be contacted outside of regular hours? What type of roles do you think? Project manager, what else? Emergency services probably dealt with more of the legal requirements because legally they're required to be able to be connected. Who else? Yeah, carer support, yeah, that's a good one. Murray? Truck drivers, okay. Surgeons, yeah, absolutely. So anything in the medical space would make sense. Another one is any organisation or any position that's dealing with different time zones. Yeah, so if you're working with overseas clientele or overseas, even overseas employees, yeah, managing overseas employees. So that would be quite reasonable, would you say? Yeah. Now, there are a few things we need to consider though. Because one of the reasons why it was brought in, as what Dan said, is to provide balance. That is the whole idea of right to disconnect. So what is the major issue that we need to consider? I'm pointing at it. So, yeah? Family and care responsibility is probably going to be the major issue. Now I have a question for you. If there is a refusal to, if we have to say that the refusal to connect must be reasonable, how do we know if an email or a text message or a phone call is urgent? How will we know unless we check it? How do we know if something, if there's a phone call, a missed phone call, how do I know that it's going to be really disruptive if I don't answer that phone call unless I actually answer it or read the message?
If you headline it, you don't.
You don't. So the right is what? What's the right? Does anyone remember what the right is? The unequivocal right is not to monitor, read, yep, right? Including contact from third parties, yeah, including clients, for example. But how do I know as the employee that's reasonable to connect? How do I know?
The disruption.
We go further into this, okay? So most modern awards have a right to disconnect provision, or most modern awards. Now, this is what the Fair Work Commission have drafted into the modern awards. So those who know, you guys know what modern awards are, yeah? Yep, it's the baseline industrial instrument that governs most of you here. There might be some that don't have awards, but most of you will have awards that govern your wages and entitlements, or for your staff, sorry. An employer must not directly or indirectly prevent an employee from exercising the right to disconnect under the Act. When I look at that, when Jonathan is there sipping his whiskey, looking at this term, what troubles me so about this clause? Who said that directly? You can have a chocolate, sir. You can have a chocolate. You're before breakfast. Oh, here we go. You can have it afterwards. I'll do it. Yeah, so indirectly. Why does that trouble me so? Yeah, exactly. Directly, understandable. We can control that. We're controlling that communication. We can say to a staff member, for example, hey, Narelle, if I'm contacting you outside of the business hours, it's really important, please. There might be levels. If I text message you, lower priority. But if I'm phoning you, something's gone bad. Please answer. Or just give me a call back as soon as you can, yeah? Whatever you're doing, give me a call back, yeah? It's urgent. And it's not going to happen very much. Very, very rare. Make sense? But indirectly, what could that be?
A customer.
Customer, client, what else? Sales reps, yeah, could be sales reps. We don't necessarily have much control over that. Does it make sense? Okay. All right, so whilst you're eating breakfast, I have a question for you guys to discuss. Considering the workplace right to disconnect, what steps, if any, will your business need to take to comply with legal obligations? Now, some of you might say, all good, all done and dusted, that's great. Maybe share what you guys have put in place. For those who might not have anything or haven't thought about this, considering what we discussed, what would you want to have in place? Okay, what steps would you need to take? All right, go ahead and discuss while you're eating breakfast, yeah? All right, everyone. Just wary of time, guys. I want to get through everything. So, all right. So what steps, if any, would you take? I think that's a good one, yeah? So you're avoiding the ambiguity by making it very clear, yeah? So you might have something that happens in your business constantly and has happened for a while and there hasn't been any issues. But this is the problem, right? So this is legislation. It's not something that we can't just ignore. Okay, we need to actually consider it. Now, I'm not saying that you should go to a lot of expense and go through a whole rigmarole. You can, and you have to assess that risk for yourself. But if you don't have it documented, a lawyer like myself can't rely on anything to defend you. That's the difficulty. Okay, so if you don't have it, if a custom and practice is a fair enough argument, by the way, it's a fair enough argument. But to do that, I need to get over the hump of actually establishing that it is a custom and practice. And the only way I can do that is by how? How can I establish custom and practice in your business? How? Well, let's say we don't have any documents to support it. How? How can I evidence that? Well, I can. By who? By talking to who? People. Yeah? Now, if I'm trying to get oral evidence or evidence from people, what is the problem with that? Sorry? Yeah. Inconsistency. They can forget. They're like, oh, I'm not actually sure. Oh, I'm pretty new here, so I don't know. And all of a sudden, what was the employer thought was very custom and practice and very standard actually is a little bit less unclear. Okay? So that's where maybe things like training might come into play, okay? Especially with your management team. Yeah, training might be a good one as well. That is, so, in terms of potential solutions, right? So technology, the one I was going to bring up was, delaying your message, your emails, your messages going out. So that's one way. I also work at night. That's where I do a lot of my work. And I'll make sure that I try and delay those emails going out. I mean, the issue is sometimes that my staff then get, emails, a whole pile of emails at 8 a.m. in the morning. But, okay, that's another issue. But again, that is just part of what I'm trying to do to make sure that they have, they get their rest or whatever they're doing at night time. Your policy. So now, if you don't have a right to disconnect policy, you don't necessarily have to have one. I'm not saying you should. But if you are in an industry where this is going to become an issue, all right, a very big issue, you really should consider something along this line, whether it's going to be flexible work practices or something like that, where there's a policy that sets down pretty much what is the standard in regards to discussion or communication or anything else outside of regular work hours. Okay? Again, what's the thing? We're trying to avoid ambiguity as much as possible. Okay? Try to make it clear. If you've got different time zones you've got to deal with, flexible work arrangements, okay? Around that, so essentially the whole swings and roundabouts, yeah? Okay? And that goes with any type of flexible work arrangement as well, yeah? Again, is it clear? Is it clear? How is that clarified? Is it just because of someone's got in their head? Again, if I asked Nairi or if I asked Jason the recollection of the events today, I suspect they'll give me two different recollections. Okay? So that is a thing. If you don't have clarity, this is where this might become a problem. All right? Employment contracts, so in position description, so if you have a position, usually a more senior position or maybe a sales position or project manager position for an employee, and you don't have it set down very clearly that they can be contacted outside of hours, that they can be working outside of those hours, you need to get your contracts reviewed. Okay? That's very simple stuff. That's good hygiene stuff. Get it done. All right? That's a ticking time bomb. All right? Communication on expectations, very simply. Here are the expectations of the role. Okay? Document that somehow. Okay? That's very easy stuff. All right? And then if you want to get to the next level, probably that sort of guidance, training for your management teams. I suspect it's not going to be necessarily the managing directors or the CEOs that are going to run afoul of this. I suspect it's going to be more the middle management teams. That's where we're going to have problems because they're the people on the ground dealing with it. The supervisors, the team leaders, that's where there's going to be some problems. So guidance for them, understanding what their parameters are going to be, why it needs to be in place. Okay? So just have some clarity for them. Does it all make sense to everyone? Okay? No, but remember, you can put anything in a contract, but it has to still be reasonable. Okay? So if you yours is going to be very difficult because you have, so if you have, say, a manager and the expectation is they're going to be on call and we pay them for being on call, not going to be a problem, yeah? Your situation about apprentices, that's a bit more problematic. That's not quite right. You can enforce a contract, okay? You can enforce a contract employment, but that is a process. It's about whether you want to actually go through that solution, because it's not going to be, for you, it's not going to be very straightforward. It will be quite, it'll be rough. But there are solutions, okay? So there are solutions, but it's not going to be as straightforward and easy for you, okay? And you can enforce a contract, but it does cost time and money, okay? So you've got to weigh up commercially whether it's risky, whether it's worth it, okay? You do have to weigh up those commercial risks. So I'm not saying this is very straightforward. I'm just saying that there are always solutions to each of the problems. You just may not like what that means to get to that solution. All right? It may cost you quite a bit of money, probably a lot of time, yeah, and a lot of effort, but you can get there. So there are penalties. So with right to disconnect, there are now in the modern award, so it's technically a breach of the modern award as well. So that attracts penalties. It's a workplace right. So has anyone heard of general protections? Yeah. So if you run afoul of general protections, so that's when an employer takes adverse action against the employee because they exercise or post-exercise a workplace right. Okay. That attracts penalties. Okay. It doesn't just attract compensation, but attracts penalties, quite high penalties, but also penalties for individuals as well. Okay. So it is quite serious. Now, has it been really utilized yet? Not yet. It's quite new still, okay? But it has been added to, where do you think this is really hurting at the moment with companies? So it's not so much right to disconnect by itself, it's they've been performance managed, yeah? Maybe they're on the verge of termination of employment or have been terminated. Maybe they made a number of complaints. Maybe there's a workplace bullying issue. This is when this comes up. Sorry, not that. Right to disconnect, yeah? That's when that comes up. So right now it's been added to like a work cover claim, or it's been added to a complaint or a bullying complaint. That's what's happening right now, okay? No one's necessarily using it by itself. It's just been added to a layer of something else. An easy one, mate, is a policy. You may not be able to change your contracts, especially for your staff right now. It's not as easy to a variation of the contract. Policy in place, this is what happens. Sorry, I've got to move on, guys. I know that's a hard-hitting topic, but I do have to move on. So contractors and contracts. So there's been some changes around contractors and contracts. So what we've always had is what we call the multi-factor test. Now remember, I'm not an accountant, so there is a different definition for contractor under taxation law. Also, I'm not a superannuation lawyer or anything like that. There is also a separate definition for superannuation for contractors. Do not ask me questions about tax or super. I will not have the answer to it, okay? But they are generally different. Generally, yes, there are similarities, but they can be technically different, okay? All right, but what we used to have is what we call the multi-factor test, case law. So basically, to establish whether someone was a contractor or an employee, we would go through a case law and say, hey, this is a magically made up multi-factor test. That's basically what we did, yeah? That's why we had so many problems, okay? Generally, it came down to these things, yeah? Hours of work and leave, ability to delegate work, ability to perform work for others, provision of tools and equipment, terms of the contractor agreement, and the main one being control. Do you have control over the contractor? Because as an employee, you have control over the employee. Yeah, that was the big one. Then, in 2022, the High Court had to deal with two very specific cases, GemSec and personnel contracting. For those who are in labour hire and construction building, you would have heard of this case. High Court cases, similar-ish facts, yeah, similar-ish facts. But basically it came down to this. Were the employees or the staff, the workers, were they considered an employee or a contractor? There were different situations, but it was a crux of the case, okay? The High Court says, which is the highest court in Australia, said, we know this is going to be potentially a precedent. We're going to take our time and we're going to establish a precedent for what is a contractor, what is an employee. That makes sense. Yeah, make it really clear for everyone. So this is what they said. We are going to make sure that the contractual written terms is the first and primary thing we look at. So if you've got a contract agreement, prima facie or on the face of it, they are contractors. Then we look at the rest. Yeah, then we look at the control and whatever else you've done. So, lawyers across the land said, phew, that's fantastic, guys. So basically, if we just make sure the contract agreement's nicely put together, yeah, we make sure that in practice, it actually happens. So you still got to make sure that in practice it actually happens, right? There's no control, okay? They can delegate work to others, they can work for other people. Great, makes sense. But the government had an issue with that. So, unfortunately, that was then changed again on the 26th of August. So, what happened was, we've now gone back to a different definition. So when we look at a contractor argument, we look at what the real substance is, the practical reality, and the true nature of the relationship between the parties. Basically means we've gone back to the multi-factor test. Okay, so this becomes problematic in many situations, okay? Because in some respects, they've actually not just dealt with the contractor issue, they've also dealt with contracts, employment contracts, and to some extent, they've dealt with casual employees as well, all in one hit. All right? So basically, it's the same argument. Is this a casual employee? What's the real substance? What's the practical reality? What's the true nature of the relationship between the parties? Is this a contractor? Bang, bang, bang. Hard to actually answer that without you have to go through this, basically. Yeah? You have to. Same with casual. What would be the provisions for a casual employee? Mm-hmm. What will be some of the main things? Yep. Well, yeah. But what's the main difference between a permanent employee and a casual employee? What's the main differences? Sorry? Entitlements. Okay. Leave entitlements is the main one. Yep. What else?
Their work is constant.
Yeah. It's meant to be up and down. What is the traditional casual employee arrangement? Where did casual employment come from? Exactly. Simultaneously starts and ends at the end of shift, technically. That's what meant to happen. What's happened over time? What's happened over time, though? Well, it's just easier roster-wise if I just put them on a regular roster. They like it, we like it. There's certainty, but then it becomes what? Starts melding into permanent. Yeah, we start getting more constant work. Okay, so this is where we've seen some changes now. Okay, so who has contractors? Anyone any contractors? Okay, well, we don't have to worry about this then. All right. Oh, you do? Okay, so just the main issue here is that contractors, if they earn more than 175, can actually opt out of this whole, all these issues. They can just opt out of it and say, hey, I'm a high income contractor. I'm a contractor. Boom. Yeah? Because my accountant likes it. I don't know. Whatever the argument is. Yeah? All right? Interestingly, if put forward, the Fair Work Commission can review the terms of agreement. So if a worker says, let's say a worker gets injured, that's usually where it happens, yeah? Worker gets injured and says, hey, I'm injured. Work cover said, well, Where'd you get hurt? I said, oh, I get hurt at the, at the site of NRG. Are you an employee or a contractor? Well, I've been working there for quite a while now. They're my only people I work for. I mean, technically I'm a contractor, but actually I'm probably more an employee. Why? Why do they say that? Because they don't have their own insurance. Boom. All right, so then we have a problem, yeah? That's where it usually comes out, usually. There's also tax reasons and superannuation reasons, which I will not go into, of course, because I am not here to talk about tax and super. Yes, it's not a tax and super question, is it? Good, all right, go. So the big thing there you've got to make sure is your terms, your written terms of the contract arrangement set out very clearly and specifically. They need to have their own insurance, they can work for other people. It needs to specifically say that, because that's going to be at least an argument, because control is going to be a problem. You're going to have a problem with control, right? So yes, if we had still a gem second person contracting, that's all we'll, to some extent, all we'll need. But we're back to this. So we have to at least set out that. That's your starting point. After that, you need to probably put some more parameters around, look, you can work for others if you need to, and almost remind them of that, yeah? Oh, sorry. There used to be a defense for sham contracting, which was essentially, I call it ignorance, but basically, I didn't know. That's been completely removed. Okay, so if you engage in contractors, because that's the result of this. Yes, there's work cover, yes, there's all these other issues, but sham contracting is probably the big one. Sham contracting attracts huge penalties. Okay? All right, so can we, that's really small, I apologize. Lasso Cleaning Care. All right, so they provide cleaning supplies to council facilities. This is, of course, a made-up company, all right? It is not based on any company in particular, all right? Nathan's a sales executive. He's a casual. He's been tasked with taking care of the New South Wales and Queensland market. He spends long stretches alone in his car, driving from facility to facility. His contract clearly states that he's a casual employee and works from 9 to 3, Monday to Wednesday, and has done so for 4 years. Nathan also works as a contractor for Richmond Care Services as a business development rep on an hourly rate of $12 an hour. He does this on an ad hoc basis and is in the process of setting up his own business to expand his services. Nathan has been in discussions with Rebecca to come and work for him with a view to provide BD services to LCC and RCS. Nathan, however, injured his hand whilst on an RCS client site and is making a claim to work cover. Nathan has requested to become a full-time employee with LCC and has filed an underpayment of wages claim against RCS after he started receiving less work from them. All right, so we're going to talk about this as a group, all right? So U3, you're facing those three, so U6, the same with U6 as well as a group, all right? Same thing over there, 3 and 3. And I think there's 4 and 2 over there at the side there. All right, you're going to discuss. So what are the issues here when it comes to what we just talked about, the contractor side of things, casual employment. There's probably some other issues there you probably spotted that are pretty easy to spot as well. Okay, so let's talk through the issues. What are some of the main issues and what are some side issues we have to deal with, okay, with Nathan here. All right, off you go. Because this is live. So it's all well and good to bring you all these nice case studies, nicely wrapped up in a bow, but this is what it looks like. And usually, I brought this together nice and neat for you so you can have a look all and go, oh, well, you can make judgments. Most of the time, lawyers get this in bits and pieces, right? And we have to somehow put the jigsaw puzzle together, all right? I've at least put the jigsaw puzzle together. Now you've got to decipher it a bit, all right? Now, what's the first couple of things that stick out to you? But it says very specifically in the employment contract, he's a casual employee, he gets paid casual rates, works from 9 to 3, Monday to Wednesday, and has done so for 4 years. No one's had a problem. He hasn't had a problem, I haven't had a problem. Now, what problems does that create for us? Because let's say, Dan, I offered you casual employment. You didn't want it because you're working the same hours, you would have got a reduction in pay, you won't get your leave. So you didn't take it.
I don't remember that.
I remember that. I don't remember that conversation.
They can reject.
Yeah, I haven't documented it. Yeah. Yeah, it's a problem. We have a problem, yeah? Okay. What else? Yeah, so potentially, if it can be established that they're a permanent part-time employee, that there's going to be leave entitlements. But then someone says, and a great comment, wait on, they're a casual employee, they get paid casual rates. The whole idea is that it's higher, and it does include things that it's essentially inclusive of leave entitlements. What do you say to that argument?
Well, apparently it's lost a couple of times before.
Yeah. So, yes, it could help with liability, but there's still a breach. Okay, so don't mix up, that's all nice and reasonable. Commercially, yes, that's going to be a commercial argument for liability. So, i.e., we shouldn't have to pay too much, or we shouldn't have to pay as big a penalty, but it's still a breach. Okay? The contract law is a different jurisdiction. Okay? Then you have underpayment. Then you have award breach, if there's an award, or an EBA, depending on what you have, yeah? And these attract penalties too. So it's not just compensation, but penalties. And over here, they can also then sue for breach of contract over here in a different jurisdiction too. This goes through the commission. This goes through, depending on how much it's worth, mags court or district court. What else sticks out to you? Yeah. $12 an hour, contractor. So, gee, I hope this guy's a contractor, because if he's not a contractor, we're in trouble, yeah? What are we in trouble with? Well, look, we don't know exactly how much, but we think we pretty much go, $12 is probably going to be underpaid, yeah? No matter how you slice it, it's probably going to be, okay? All right, what else we got? Yeah, so is it, like, if you just have an ABN, is that okay? I'm a contractor, I've got an ABN. Boom. What else we got to look at? Contract, insurance, ability to delegate to others, ability to work for others, yep. So all those multi-factor test things, yep. All right, what else? He's gone out to get some services or other work. So potentially that's a misuse of confidential information, yep. So there could be contact information that he's using. It's council work as well, so there potentially some problems there with the council legislation. What else, sorry, was the other thing? Conflict of interest, yeah, potentially there's a conflict of interest there as well. It's working for two opposing cleaning companies. I wonder if they know about each other. Yeah, okay. What else?
On one hand, it states that he's a contractor for the second company.
Yeah.
Then it says he filed an underpayment of wages.
Why?
Well, he's now injured.
Yeah, so this is all going well for LCS and LCC and RCS. All going well, it's all swimmingly. Maybe there's some questions asked, maybe not. It's been going on for 4 years. Contractor, may I pay him $12 an hour? That's pretty sweet, no worries. It comes to a head because he injures himself. Now, why is he suing for underpayment and filing a work cover claim? Why? Why now? Ah, very good. Very good. Yeah? Doesn't have insurance, or likely doesn't have insurance, or at least doesn't have some type of protection. I'm in trouble. You know what I'll do? Actually, there's an underpayment of wages issue here. I'm going to murky the waters, sue everyone I can. I want to say to work cover, yeah, I've been an employee the whole time, mate. Whole time. This is actually sham contracting. Oh, that's the sham contracting now. See how this becomes messy? What are we missing here from both those companies? What are they missing? Policy procedures, control, what else? What's the main thing they don't have? Did you say clarity? Clarity. No ambiguity. Did you learn something? Yes? Good. All right. Wage theft. Let's get into it. So this is probably one that most of you have really heard a lot about because it's just come into play federally. Yeah? So in Queensland, we've actually had wage theft laws since September 2020. We've actually had it for a very long time. The federal laws pretty much copy our laws pretty much to the T, except for some of the background issues, which I'll talk about in a moment. Now, there was a number of high-profile underpayment of wages claims, cases, yeah? So there was the MasterChef guy, George Columbaris, there was 7-Eleven, Chart Time, there's so many. There's been so many, yeah? Even Woolworths got caught up in one, yeah? Okay? Now, this prompted the wage theft laws in Queensland in September 2020, all right? They were enacted. And essentially what that meant was, and I'll explain that in a bit more detail, essentially what it meant was that there could be criminal prosecution for underpayment of wages. Essentially could be referred to the QPS. All right? Now the big change recently is that on 1 January this year, federally wage theft is in place. So all across Australia. Now let's break that down. Has wage theft, remember we've had this since September 2020 in Queensland, has wage theft led to prison time for anyone yet? Yes or no?
Yes.
Who puts a hand up for yes? Who puts a hand up for no? Yeah. So no, we haven't. Why? Okay, well let's explain what wage theft is. So wage theft, you need to have an underpayment of entitlements. So it has to be, it's absolute. There is an underpayment. Underpaid annual leave, underpaid allowances, underpaid on the award, whatever it is, there's an underpayment of wages. We're not talking about a contractual amount though. We're not talking about bonuses, nothing like that. We're talking about straight out an entitlement. Hasn't been paid or is underpaid, all right? So that has to be established. The second part is, has there been dishonesty or intention to steal or defraud? All right? If you have the second part, so it can't just be a mistake. If it's just a mistake or a payroll error or something like that, okay, that's just underpayment. Still underpayment, by the way, and there's penalties for underpayment of wages, but it's just an underpayment. But if you have dishonesty, intention to steal, defraud, put that together, and that's what you have, wage theft. Okay, so it has to have two parts to it. So what can underpayment of wages, what can they be? It could be just unpaid wages, or simply haven't paid any wages. It could be not paying any national employment standard entitlements, such as annual leave or sick leave or leave loading or whatever it is. It could just be simply misclassifying an employee under an award, so different awards. Yeah, that could be a big mistake. And so you might have an employee that should have been on the black coal mining award and not getting those entitlements, yeah, as an example. Yeah. So what's happened? Well, wage theft is a criminal offence. It has to involve entitlements, but not contractual, as I said. There's two parts to it, absolute liability, intention. There's an exemption. Honest mistake. If you made an honest mistake, that is an exemption to wage theft, all right? There's also what we call a voluntary small business wage compliance code, which came in on 1 January. Now, I've had a read of it. It's quite reasonable. So basically, it has things like, have you checked the award? Yep. Have you classified it properly? Have you sought external advice? Like, it's quite simple. Yeah. So you just go through that code. If you're a small business, you can utilize that code and you can show and say, hey, we've done all these things. Okay. Maybe not exactly perfect, but we've done all these things, but we've still made a mistake. Apologies. Yeah. So the change here on 1 January is that The Fair Work Ombudsman is now going to be primarily responsible for investigating the new criminal offence. What happened in Queensland? Well, this is what happened in Queensland. This is why it never really took off. So let's say someone established that there was a wage theft, there was underpayment, there was dishonesty, okay? They'll be packaged up and given to the Queensland Police Service. QPS, to be honest, didn't really know what to do with it, okay? And didn't have time, all right? And so, and it could have come from anywhere. It could come from a regulatory body, it could come from a union, it could come from anyone, all right? So there wasn't any criminal prosecutions, but it's different federally because the Ombudsman is actually the ones investigating and they actually know what they're looking for. So now, when they're looking for underpayment, they're not just looking for underpayment, they're looking for dishonesty. Yep, or fraud. If they've got those two parts, they will then package it up nicely and give it to the Commonwealth Director of Public Prosecutions and the Australian Federal Police. So the answer is, federally, it's going to be much more serious because you actually have two organisations that actually know what they're doing in terms of dealing with this situation, okay? All right. Does it make sense to everyone? Yeah? Okay. All right, so penalties are quite extensive. So it could be up to 3 times the amount of the underpayment. It could be up to $7.825 million for a company. And it could be up to $1.565 million for an individual. Okay? So that's the financial penalties. Prison time, up to 10 years imprisonment. So quite serious stuff. Again, this is not about the ones who are honest mistake. You might have a payroll software, you made an error and it's compounded. That happens a lot, yeah? So you misclassified or you've just paid incorrectly and it's compounded. You might have had a payroll officer that's made a mistake. That's not what this is for. That's an underpayment of wages. You still got to pay potentially penalties and compensation, all those types of things. This is about wage theft. If you've done it intentionally, then we have a problem. So all those restaurants that were deliberately underpaying their staff won't be able to get away from this anymore. Okay? It's not just about them being able to phoenix later. They will have to pay the consequences criminally as well. Well, from 1 January, they might have some problems, yeah? So, so let's look at the legal responsibility. Let's look at Wimbledon Finance. Wimbledon Finance, they've got an enterprise agreement in place. They're based in Byron Bay, and they've got about 200 staff, okay? An individual flexibility agreement was prepared by a consultant and has been in place for a number of years, which was issued to all employees. All right, does anyone know what an individual flexibility agreement is? Essentially, it varies the terms individually between an employer and an employee, varies the terms of a modern award, okay? Or varies the terms of an enterprise agreement, okay? The IFA provided 10% more base rate pay, okay? And substantial bonuses in exchange for employees foregoing the rostered days off entitlements and overtime, all right? The enterprise agreement requires a yearly review and a top-up payment if necessary. So if there is basically a shortage, they'll do a review basically at the end of the year. If there's a shortage, they'll just top it up, okay? So, Wimbledon Finance, though, has gone through a number of issues, including 5 consecutive negative profit quarters. They've had a new CEO, they've had understaffing problems, and they've also had the dreaded payroll software changeover. They've had any issues there. Andy, a payroll officer, has become aware that yearly reviews have not been undertaken. However, he has been expressly directed by the finance officer to ignore this and that the consultants will take care of it and the new software will provide any new compliance updates. Okay, so question for you. Has Wimbledon Finance engaged in wage theft? Yes or no? Yeah? Why? So do we have an underpayment? Yeah. So not sure. So where do you think potentially could be a problem in terms of an underpayment in this scenario? Yeah, that's the intention side. But what about the liability? Yeah, we missed the yearly reviews. Yep, we just haven't done them. Like, right? Sorry? Yeah, so we've got individual flexibility agreements, but correct. So we don't know. But it's done by a consultant. It's okay. It's fine. So maybe we have some problems with the IFA in terms of its terms. The biggest problem, though, is it says we have a 10% increase in base rate pay. Yeah? Got some bonuses, but what's in exchange for? Roster days off entitlements and overtime. Now, if you have an exchange of entitlements, you can do that. There's nothing wrong with that as an IFA. But specifically, the enterprise agreement says there needs to be a review. If there is a difference, because that's the whole idea, if there's a difference, it needs to be topped up. All right? Now, I've already said there's 5 consecutive negative profit quarters here. So we've at least got 1 year where we haven't done the review. Potentially more. All right? What else? So potentially, we might have an underpayment. We don't know, but potentially there's an underpayment. What else?
Well, there will be an underpayment if they have another 10% increase in base rate.
Because what's the normal increase in any CPI, yeah? So it really, probably 10%, you're probably only looking at 2, maybe 3 years, depending on what type of industry, well, finance industry, so a bit different. But let's say 2 years. So there potentially is an underpayment. But the thing is, we have no idea.
The CEO isn't going to jail because he wouldn't have a clue.
It's relatively new, yeah? So where's our problem? Where's the intention problem here? So it's a bit of a culture. Don't you worry your little head. It's okay. Don't look into this too much more. The consultants are going to take care of it, and a new payroll software is going to update everything automatically anyway. We're all sweet. We're all okay. So what happened here is that this is based on a real case, the Fair Work Ombudsman v Commonwealth Bank of Australia. The employer took a number of years to disclose this to the Fair Work Ombudsman. So essentially what was happening was there was a shortfall, but it had been happening for a long period of time. No one reviewed it because it just dropped by the wayside. We had negative quarters, change in CEO, change in payroll software, completely dropped off the radar, okay? Simply ignored. They had a penalty of 10.34 million for this. That's the penalty. You can see plus. That's the compensation after.
And that's after voluntary.
Now, is it wage theft? Why? Why are you saying no, Cassie? Do you know the answer? Yes, you do know the answer. Sorry? No. No, it's because it's 2024 and the new laws come in 2025. It's a trick question, a little bit. But there's a reason why they're disclosed in 2024. Not conspiracy. I'm not a conspiracy theorist, but there's potentially a reason why. So they got caught in underpayment of wages, but don't have to deal with the criminal side of things. If they had this issue in 2025, we might be talking about a totally different story. Yeah? Make sense?
So
Okay.
does the employee, the CFE financial officer get jailed or the CEO?
In this situation, look, we don't know, but you'd think that the finance officer is going to have definitely some things to answer to, for sure. Well, that's the whole idea. It's going after people. There's criminal prosecution against individuals. Criminal prosecution doesn't care if you're the director, doesn't care if you're the HR manager. Yeah. Yeah. Well, yes. Yeah. But yes, criminal prosecution. Yeah, criminal prosecution, and it goes for everything. So, underpayment of wages, penalties that are touched, they go after individuals as well. Okay, individuals are not immune just because they're an employee. They're not immune from this. Okay. There are of course insurances you can get in place, but talk to your broker if you want to talk about that. Okay. So, What's some of the practical steps to take? We'll stop soon to get into questions. Practical steps to take. So when it comes to underpayment of wages, you really should be doing some spot checks. Now you can do this formally. I suggest you do at least a sample check, okay? I strongly suggest you get a lawyer involved or law firm involved because you get legal professional privilege over the report. Does everyone know what legal professional privilege is? Essentially, you get confidentiality. At least as a starting point, you have some protection over those documents, yeah, in litigation, if it goes to litigation. Look at auditing your pay records, calculate total amount paid over that period, go through and establish work hours, calculate how much should be paid, is there any underpayment, look at what back pay needs to be recorded or back pay that needs to be potentially paid, any change that needs to be made, so that's your software in particular, any payroll software. Does the issue affect more than one employee? So up here, you're looking at things like award coverage, is that correct? What does the contract say? What's the responsibility? So matching that up. So especially if you haven't done that for a long time, you really should be looking at it and going, hey, actually, I think they've increased their levels. You might have done that review every year, but you may haven't either. Okay. The last step, of course, and this is where you really should definitely get advice, if there's definitely an underpayment or you think there's an underpayment, get some advice on how to disclose that to the Fair Work Ombudsman. Okay? Make sense? Good stuff. All right, so you might feel a bit like this, yeah, the Ghostbusters. So what you need to do is really understand the changes that we talked about. These are I talked about 3 changes. There's many more. There's a QR code there, get a copy of the slide deck, access to future content, of course, access to future webinars and events they'll be putting on. But what you need to do is implement a plan, okay? So before we get into questions, can we take a little bit of time? You're away from the business right now. I know that a lot of you're about to run into a whole pile of emails, and so you're gonna forget all this and all that. I understand that, I've been there, right? You've probably got some missed phone calls on your phone right now, text messages. Take some time right now. You've heard a whole pile of stuff around IR law changes today. What action from the changes you've heard today, if any, may require action? Okay. What's your description of action? Keep it simple. What may be required? Keep it simple. Don't go for the big horses just yet. Go for a small horse, little pony, yeah? What resources, skills, people involved do you need, and what other information may you require? So let's take a couple of minutes, maybe. Just have a think about that. If you've got a notebook in front of you, write down some notes, jot down some notes. All right, before we get into question time, I have a question for you guys to end this. Let's end where we started, okay? Question. Considering the many legal changes and potential legal changes, what steps should an employer, manager, and HR manager take to mitigate the risk and liability? Ensure correct award coverage and therefore wages are correct. Review flexible work arrangements. Review contractor agreements and arrangements, or contract agreements and arrangements. Undertake management training.
Run away.
It is. It's a trick question. Of course it is. Yes, all of it, all the above. That is it for me. I hope you enjoyed the session, the workshop. Appreciate all the interaction as well. And I will hand out a few chocolates at the end as well. Okay, off you go. Sorry, I'll leave with you guys. Sorry. Yep. So thank you. Thank you.
For those who have to go, we understand that. Off you go. If you have contractual obligations to fulfil. Can I recognise Donna Kirkland, Assistant Minister for Regional Queensland and other things. So it's very hard to say your name without putting councillor in front. So much appreciated. But Jonathan is still around for a few questions. Other people to thank. The Central Queensland Regional Organisation of Councils, represented here through Cassie on the Regional Jobs Committee. And please join me in thanking Jonathan. I'm sure you all found that An excellent mix of entertainment and useful information, Jonathan.
Thank you.
Okay, thanks everybody. I probably should have explained, Central Queensland Regionalisation of Councils is actually funded today, and they funded a similar session down in Gladstone towards the end of last year. So this was a project that we put to Cassie, who very kindly approved it, or went to whoever approves things. I only sit on the committee, I don't know how it works. So thanks very much for that, Cassie, much appreciated. Can you join me again, please, in thanking Jonathan?